If it may please the Court, my name is McAuliffe, initial B, appearing on behalf of the defendant. Your Honour, my client, one Johnny Wishbone, is of Torres Strait Islander descent and was born on the 29th of June 2000. At the time of the alleged offence, my client was 14 years of age and was a juvenile. Here is the situation, Your Honour. My client faces a total of 106 charges. He was arrested by police and an interview was conducted by police at the scene of the alleged offence before he was taken into custody. No notes or recordings have been taken of this original interview. Your Honour, after this initial interview at the scene of the offence, police then escorted my client, who was still under arrest at this time, into an unmarked police car. He was then driven around the neighbourhood and the area surrounding where the alleged offence took place. My client was driven to specific locations. All the while, leading questions were posed to him by police, such as, this one was you, wasn't it? And I bet you broke into this one as well, didn't you? This is a clear instance of gratuitous concurrence, as my client in this situation has been adduced into providing involuntary statements. At no time during these events taking place was any suggestion of an offer to contact a support person put to my client, this being a breach of the Police Powers and Responsibilities Act. From the material provided to me, Your Honour, the police have taken what they said my client said at this time and have put it into a statement, this statement being the basis of the case against him. None of this was put to my client at any stage. My client was then taken back to the police station and put into an interview room. At this stage, an independent support person was provided to my client. However, this independent support person was not known to him, and the identity or role of this person is not stated anywhere in the admitted evidence. The independent support person stated to my client, prior to further police questioning, that he should just tell the truth and answer the questions. Throughout this whole series of events, police were aware they were dealing with a juvenile. My client is clearly identifiable as a juvenile. Police would have also been aware of the strict legislative requirements that they must comply with before undertaking questioning of a juvenile. Due to the failure of police to adhere to these requirements and the failure to organise a support person of my client's choice, I suggest the police were in clear breach of both the Police Powers and Responsibilities Act and the Police Powers and Responsibilities Regulations. Your Honour, under Section 421 of the PPRA, a police officer who reasonably suspects a person to be a child suspect cannot proceed with questioning the person unless the child has selected an independent support person of their choice to be present at the time, such as a family member or guardian. If a support person of choice was provided to my client in this situation, then this may have been a completely different story, as it is reasonable to assume that this person would have told my client not to answer any further questions from police. Furthermore, under this provision in the PPRA, police are required, when questioning an Indigenous suspect, to also contact legal aid unless they believe the person is not at a disadvantage. Due to my client's age and the aforementioned gratuitous concurrence, then it is clear to any reasonable person that a disadvantage was present in this instance. Therefore, legal aid should have been contacted on my client's behalf. Under the Police Powers and Responsibilities Regulations Section 25, police were required to ascertain my client's level of education or understanding in order to determine whether my client had a capacity to understand or answer the questions posed to him. Your Honour, it is clear that my client did not have the capacity to fully understand the questions posed to him, and it is also clear that the PPR regulations were not followed, as this factor was failed to be considered by police. This should go toward the inadmissibility of the evidence against my client. The failure of police to comply with requirements under the PPRA and the PPR regulations directly conflicts with the purpose of this legislative instrument. Section 5 of the PPRA states that the purpose of the legislation is to provide police with the powers necessary for effective and modern law enforcement, and, more importantly, to ensure that the fairness to and protected of the rights of the persons against whom police officers exercise power under this Act. Your Honour, it is blatantly clear that the purposes of this Act have not been achieved in my client's situation. There was nothing fair whatsoever about how my client was dealt with by police on this occasion. Your Honour, I ask, after considering the relevant sections in the legislation that I've outlined, that the Court consider the inherent judicial discretion as set out under the principles of Bunyan and Cross, and that this discretion is exercised against my client with any statements submitted by police rendered non-admissible as evidence. My submission is, Your Honour, that after you find these sections of the relevant legislation have been breached, that the Court then take the next step and not allow the filed evidence against my client to stand, as this is the only piece of evidence against him. Thank you.